of the Penn State Center for the Study of Sports and Society, and Jodi Balsam, professor of clinical law and the director of externship programs at Brooklyn Law School, and two friends of the SLA. Welcome you both.
Thank you.
Thanks. Thanks. Great to be here.
So before we get into today's discussion, which is going to be about this FUBU Venu case, which briefly, for those that don't know, which would be shocking to me, FUBU is a virtual MVPD, a video service, and they sued a joint venture that has yet to launch and the court in that case made a determination that FUBU was more likely to be successful and therefore granted the preliminary injunction, which puts a pin in the launch of this joint venture, which was to have started this week. So before we get to that discussion, starting with you, Jodi, could you give us a little bit about what you do now and just sort of your path to how you got there?
Sure. So I started out after law school in big law, working in mostly antitrust litigation and counseling. That led me to a dozen years in-house at the National Football League, where I had a far broader portfolio handling everything from internal dispute resolution procedures to litigation management to Super Bowl contracting. And then I switched gears and moved into academia, where I've been at Brooklyn Law School now for 10 years as full-time faculty running their de facto sports and entertainment law program.
Great.
I probably should also mention along the way, I have also served as an arbitrator for NCAA infractions and an on-air legal commentator for NBC Universal's The Golf Channel.
And Steve?
So I spent by accident 6 years in training to be an academic, working at the Federal Trade Commission, the Antitrust Division's appellate section, clerking on the DC Circuit, and then working for a U.S. Senator. So I really got to see all of government. I spent 20 years teaching at the University of Illinois College of Law, and the last 18 at Penn State, where I teach both sports law and I co-direct a cross-campus multidisciplinary center. Along the way, I do a lot of sports advocacy on behalf of consumer groups and do a variety of consulting with various sports organizations. And I would also mention to viewers who are looking for building skills, it's been my privilege to be a co-author with Jodi Balsam on a Sports and the Law casebook. In addition to her vast expertise and insight in antitrust law, intellectual property law, and how sports leagues work that she talked about, Jodi has this amazing attention to detail that is a critical value-add skill. So those who are viewing, who are thinking about how do I get in and make a difference in the sports industry, I can assure you that in addition to her experience, and not because she is a supporter of the Arsenal Football Club, but because she has a great attention to detail, she's a really valued co-author.
Well, I appreciate you saying that, but I think you're overstating. Basically, what I do for Steve is I clean up his early drafts.
Well, we, for what it's worth, for the first time I've done anything with Steve, I'm not wearing a logoed Cal gear. For the audience, Steve and I are undergraduate classmates, so go Bears. Anyway, on to today's discussion. So this is an antitrust case, and most of the time when we see antitrust cases, people are talking Sherman Act, Sherman Act, Sherman Act. This decision never gets to the Sherman Act. It only starts with the Clayton Act. So would one of you take the lead and sort of give us the distinction and the path the court took in this case with using the Clayton Act?
Let me start with the law, and then Jodi can weigh in on litigation, which she's more familiar with. The Sherman Act prohibits conspiracies in restraint of trade, and that is the main action that many people are familiar with all the NCAA actions. And it also prohibits monopolization And you go back in the case law, that was relevant when the USFL claimed that the National Football League had maintained their monopoly and put them out of business. This is a different act called the Clayton Act, passed in 1914. And the statute is worded in a very different way. It prohibits a merger or something that, or a combination of assets where the effect may be to substantially lessen competition in any line of commerce in any section of the country. And it was specifically passed because of concerns that a more conservative Supreme Court would not, under the rule of reason that courts now have been using ever since 1911, be sufficiently attentive to anti-competitive mergers. It's a predictive statute. And so it's very different than what we've seen in some other major sports cases.
So while it's a predictive statute, it still requires there to be some factual basis, non-speculative basis for anticipating that a proposed merger will be anti-competitive, will hurt markets, will hurt consumers. And to me, that's the flaw in this case. That's the flaw in the judge's decision to enjoin the Venu joint venture, that we're talking about a market, the television market, and more narrowly, the sports television market, that is right now going through a great deal of disruption and change. And it's very hard for anybody to anticipate, including those who have worked in sports television for decades, what's going to happen next. And here we have a judge jumping in and deciding that regardless of the constantly evolving landscape right now, this particular joint venture, which, by the way, delivers a product that consumers desperately want, is anti-competitive and should be enjoined.
Well, this raises a really interesting point that, as the TV lawyer here in the room, what we're talking about historically is that when the networks obtained these rights to broadcast the various sports, they were limited to the distribution over the over-the-air channel, which of course doesn't really exist anymore, but the right to enter into retransmission agreements with MVPDs, cable companies, satellite companies, to take their whole signal. In fact, the leagues used to have a provision, which apparently has changed, that would say you cannot carve out and sell sports-only products. If you're retransmitting your signal, it has to be the entire package of your network. Now, apparently, there's been a change because, per the proposed joint venture, they could create a sports-centric product, bringing these three parties together. My question for you guys is, the judge seemed to spend a lot of time talking about 54% of the total sports market, when in fact Warner Brothers Discovery no longer has the NBA, so it seems that number has dropped a lot. Is there some magic number or a magic percentage that would sway a court?
It keeps changing. The magic number keeps changing over time, and as you point out, traditionally in the antitrust precedents, these are stable industries where prior market share is a good predictor of future market share, which may not be the case here at all. The challenge is that the court had to pick a line of commerce where competition was being restrained. And this particular judge focused, as Jodi pointed out, on a sports TV market, and we could talk more about that. But when the judge is explaining what the judge doesn't really like about the case, it seems to me to be clear that they're really talking about problems in the distribution market. And if, again, just for viewers who aren't familiar, the judge correctly, I think, identifies this market as a three-tier market. You have the creation, that's the NFL, the NBA, English Premier League. Then you have the programmers, that's Fox and Warner Brothers, that's the parties here. And then you have distribution, and that's your cable system or Fubo or some other streamer. So there's 3 tiers to the market. What most people know is that traditionally distributors would force people to buy an incredibly expensive package and could not get just the programs they want. That can't happen in a competitive market. You can't, no, in a competitive market, you can't make people buy stuff they don't want in order to get stuff they want. So one of the things that these guys are doing is trying to get around that by selling something directly to consumers. And in that sense, it's a new product. The problem is, and then there's a precedent for this, which is a case called US versus Columbia Pictures, referred to as the Premier case. Way back in the day, the only way you could watch movies except on commercial TV was from HBO. HBO had a virtual monopoly unless you went to the movie theater. And to break that monopoly, the 7 top movie studios formed a joint venture called Premier to sell their movies directly to people and break the HBO monopoly. The court enjoined it. The court said, this is actually a good idea. It's good to provide an alternative, but it doesn't have to be all 7 of you. 4 of you could get together and produce this. And then the other 3 could either form a rival venture or keep working with HBO or whatever. That would be a more competitive result. Again, back in the day, for many of your viewers, when ATMs were new, all the banks in Omaha, Nebraska formed a joint venture to provide ATMs so you can get cash without having to wait in line at the bank. That's very innovative. The court enjoined it. They said, we don't need all the banks to come together. And so the real question here is, does this venture have the power to charge more to consumers than they would be able to charge if they were not merged? And that's unfortunately what the judge never really analyzes, but that's the key question.
So I'll just jump in here and say that the judge in this case and other commentators have drawn the same analogy that Steve has to the Columbia Pictures Premier case. But I find that to be non-analogous. All of the content in the Columbia Pictures Premier case was going to be locked up in their bundled product and unavailable on other platforms or to other distributors. That's not the case here. The content that Fox, Disney, and Warner Brothers were bundling in the skinny sports bundle would still be available on every other platform and to every other distributor, including Fubo. I mean, what's happening here is Fubo is essentially a distributor, a middleman between creators, programmers, and the consumers. It doesn't create anything. It takes a profit from distributing what others create. It's an online bundler, very much akin to the legacy cable and satellite bundlers like a Comcast or DirecTV. It has no entitlement to include any creator or programmer's content unless it successfully negotiates and pays for that rights, right? So that's what's happening here. And the individual content creators and programmers are entitled to sell their rights in a bundle or in a similar package. That's how they sustain their business model, and that's how they're able to offer a diversity of content, some, granted, more popular than others. And you can argue that traditional cable is unfairly maligned as making people pay for channels they don't really watch, when in fact, it has actually allowed more consumer tastes to be satisfied at a lower average cost than likely would have otherwise been the case. And I think the judge here was just sort of swept up in populist dislike of cable practices, of channel bundling. And the court is complaining that the 3 programmers here, Disney, Fox, and Warner, have leverage in their individual negotiations with distributors like Fubo. Yes, of course they do. But that leverage is derived from the free market forces that so highly value what they're selling. And they've paid a lot for what they're selling. They pay huge rights fees to the sports creators to the leagues, and they have to recoup that investment and profit on that investment. And they're free to license their networks to anyone on any terms or no terms at all. The question is, can they collectively do so in the Venu product? And as I said, circling back to the Premier case, the big difference here is that their content is still going to be available to anyone else who wants to license it for cable, for satellite distribution, to Fubo. So I don't really see the level of harm or the risks that in the ATM case or the Premier case had recognized.
Yeah, it
I
seems
want to
to
go.
me, real quickly, it seems to me that the judge has taken this huge prospective leap in siding with Fubu and saying, oh, well, what's going to happen is no one's going to want Fubu anymore because they can just get this sports product, so they won't need us anymore, discounting all of the other content that may be on Fubu. That Fubu is being unfairly treated because they have to buy the whole entertainment package. But it's anti-competitive, this decision, to my mind's eye. Or am I missing something here?
So you're not missing something in the sense that there's a lot of rhetoric in an adversarial opinion that conflates harm to Fubu with harm to the marketplace or consumers. And there are some harms to individuals that actually benefit the marketplace. And then there are other cases when a participant is harmed, and it is a harm to the marketplace. Now, let me go back because you're both my friends, and so I mean no offense to Bobby, but when Bobby Hacker was working at Fox, and Jodi Balsam was working at the NFL, and they were both helping put on a great product. The monopoly product that people wanted to watch was Jodi's product. People did not say, "Oh, well, there's the Eagles Giants game." And there's an NBA game or a golf match or something, given the great talent package that Bobby Hacker negotiated to put on air, I'm going to watch Fox rather than another channel. They're choosing based on the sport. The sport is what's driving the monopoly. So then you might ask, especially today with modern technology, why is there any middlemen? Why doesn't the National Football League just market everything directly to consumers? And I would suggest that one reason is there remains anti-competitive markets at the distribution level. These anti-competitive markets at the distribution level allow consumers to be charged more money by the distributors than they would have to pay if everyone charged consumers directly from the actual sports property. And what you see in these huge rights fees is the ability to move those monopoly profits backward. So the NFL sends huge rights to Fox. Fox turns around and has carriage agreements with MVPDs. The MVPDs share their monopoly profits with Fox because it is by having Fox that generates their monopoly profits. Fox, in turn, is able to share the monopoly profits back to the NFL. And so the National Football League makes more money from this three-tier system than they would if they just sold their product to consumers. Under the antitrust laws, as Jodi talks about all the time, the National Football League has a complete legal right to charge as much as it wants for its product. The question here is, are they getting more than what a monopoly profit from their product because of these anti-competitive deals?
So let me just jump in and say something about market definition. As Steve pointed out, in the Clayton Section 7 case, you evaluate the impact of a merger or acquisition on a line of business. Also, as the court in the Fubo Venu case describes it, a defined market. So one thing I want to point out is that this is a highly contested issue. And in order to measure an anti-competitive impact, The market definition can be outcome determinative as to whether the merger would be anti-competitive. So, for example, if the market is defined very broadly to include, and this was not the case in the Fubo decision, but if a market was defined broadly to include all television content, then clearly sports content is a very small percentage of the entire television content market, everything that is distributed through these various MVPDs. And the impact of this particular joint venture would be de minimis and wouldn't pose an antitrust threat. So it's very important to know how the market is being defined. And it's interesting to sort of parse that commentary from the Fubo decision. Very early in the decision, in one sentence, the court describes sports content as one of many options or substitutes for non-sports content. And then in the next sentence, proclaims sports content to be a separate cognizable market with no substitutes. Okay, not so different from what we've seen in other sports antitrust cases. But later, that's sort of in the fact section. Later in the discussion section, when the court digs down to define more precisely the market that is relevant to evaluating this joint venture, talks about a market of consumers of live sports that are nationally broadcast. And in that market, the court asserts that collectively, Disney, Fox, Warner control a monopolistic 80%. Now, that number is already overtaken by events because Warner no longer has NBA content to offer. In fact, the Warner loss of the NBA, Warner through its TNT properties, loss of the NBA package, is going to force the parties to actually entirely reevaluate this deal. And Warner may have a very different share than the 1/3 it's now entitled to under the current deal documents. But defining the market or the line of business affected by this merger as live sports that are nationally broadcast, to me, is clearly erroneous and a huge error in the court's analysis. Because what about all the home team games that fans are keenest to watch, right? So 80% of MLB's 2,500 regular season games are not broadcast nationally. They're broadcast locally. So the court's market definition is excluding 80% of MLB games in its definition of sports that consumers are interested in watching. Same thing for local broadcasts of hockey or basketball. And there's huge evidence that local games compete with and are interchangeable with and substitutes for national games. In fact, just a few weeks ago, the New York area teams launched their own service that includes every local baseball, hockey, and basketball franchise, except the Mets. I don't know why they didn't buy in there, for a skinny bundle of local sports offered for $42 a month. Now, guess what Venu is planning on charging for its skinny bundle of the Disney, Fox, Warner sports product? $43 a month. So to suggest that these are non-competitive or monopolistic levels of pricing, I think defies what we're seeing actually happen in sports content packaging. So, and there's a further absurdity of contrasting the Fubo court's market definition with what's happening in the Sunday ticket case, for example. People might be aware that the NFL Sunday ticket package was challenged in a proceeding in California. The jury came back with a liability verdict, which was later overturned by the court. But focusing on the market definition in that case, the market definition was held to consist solely of NFL games, as if consumers of sports, if they can't watch an NFL game, they'll turn off the TV and go to sleep. Like there's nothing else that competes with it. But how is it that in one antitrust case, economic experts can convince a court that all nationally televised sports events, baseball, football, hockey, basketball, NASCAR, golf, tennis, cricket, this is the Fubo case, they're all substitutes for each other, comprise a market for the purposes of Section 7 antitrust analysis. But in another courtroom next door, NFL games are found to have no substitutes and be a defined market in a Section 1 case. This is the absurdity of antitrust.
One of the problems here is the courts are following these precedents in an adversarial setting. So the plaintiff offers a market definition and the defendant offers a market definition. Now, the court is not required to accept either. It's not like final offer arbitration and baseball salary arbitration. But typically, and certainly less sophisticated judges are likely to do so, even if the actual market definition is something else, but for whatever reason, the litigators choose not to litigate it. To me, the most useful way to think about sports cases is the approach that is taken in sports competition law cases by the New Zealand Competition Commission. And this involved a case near and dear to Bobby. It's a rugby case about salary caps for the New Zealand provincial competition. And the court uses the notion of what it calls the counterfactual. The plaintiff comes in and has to demonstrate that here is what is going to happen if you don't allow the merger, or if you allow the merger, and here is what's going to happen if you don't allow the merger, and demonstrate it is more likely than not that consumers will be better off enjoining the merger than not enjoining the merger. And the court here never draws that conclusion. The court says, I'm defining a market. I'm finding the defendants have a big share in the market. Therefore, this merger is illegal, without actually walking through a narrative of what would actually happen in the case. And what I think it does is distort what the judge seemed to be most concerned about, which frankly was not this venture, but bundling. The judge is really hostile to bundling. But the judge doesn't really focus on, although the judge has a bunch of stuff early on about the key problem is forcing Fubo to take stuff it doesn't want and forcing other distributors to take stuff they don't want. Unfortunately, the court never goes on to explain whether this venture will lessen or increase this dynamic of forcing people to take they don't want. My bet is, frankly, Jodi, Balsam, and Bobby Hacker have a much more sophisticated opinion than the judge does and than I do about how this venture will affect that dynamic where consumers want to watch a particular team or a particular sport, but have to buy other packages in order to get that.
Which is, by the way, to apply the New Zealand approach to this case, what would happen if the joint venture went forward? Because customers would get a product that they desperately want. What's happening right now in television business is, especially sports television, rapidly changing market. You've got streaming and new bundles of all sorts of stored and streamable program, most of which consumers also don't watch, and which costs consumers more to assemble for a particular collection of programming that they do watch. So instead, what consumers are doing is self-bundling, right? They are going out and buying specific streaming services, cutting the cord to cable, and putting together a package of what they can afford, which often doesn't include everything that the Venu product would give them. So if you allow this joint venture to go forward, you'll have a period of time, probably not that long-lived, in which consumers will get the skinny bundle of select sports programming that they really want to watch. But Venu is actually likely to be a very transitional product, and we see that in the fact that already one of the Venu partners, Warner Brothers, through TNT, has lost a major content that was valued by the joint venture. Venu is some sort of long-term solution for sports content creators or consumers. And even the court acknowledges this industry is in the middle of dramatic transformation, I think is the phrasing that the court uses. So consumers are already on their own customizing their bundles, and the rate of change in the sports markets highlights the absurdity of trying to apply antitrust intervention at this moment. Nobody expected Venu to be the be-all and end-all for the next 10 or 20 years. It's an intermediate product that should be allowed to go forward precisely because, in Steve's words, borrowing from the New Zealand approach, it will give consumers exactly what they want. And if they're not happy with the pricing of it, they can still get that same exact content through other bundles. As I said, this is not the premier case.
Yeah, I think one of the things that's been puzzling to me about this decision is they're actually this joint venture creates competition, so you can keep your charter subscription with a million channels, or you can get a sports product. And if I control the product, is there anything that prevents me from saying how much I want to pay if you're buying it directly from me? I mean, you buy direct from the manufacturer, you probably get a better deal than you're buying it from Home Depot or the middleman. And I don't see how this got to the level of saying it's likely lead monopolization when it's actually, to my mind's eye, pro-competitive, especially in a marketplace that's so split up, where you have ESPN about to launch a product next year that's a direct-to-consumer streaming model of all the ESPN content,
Bobby,
which is where we've been moving.
That's another reason, Bobby, why the Premiere analogy does not work. Because what you had in Premiere is almost every single major studio combining in a joint venture. Here you have 3 of the potentially 7, 8, 9 different holders of sports rights. This is exactly what the Premiere court ordered. All of you can't combine. Half of you might be able to. So half of the major sports rights owners are combining. That's what Venu is.
The narrative, Jodi asks exactly the right question, and she provides a highly plausible answer, which is what would happen if you allow it to go forward. But the real question is to compare that prediction with the counterfactual. The counterfactual that would make it anti-competitive is if you don't allow this venture to go forward, the 3 of them will operate their own venture. And that would be more pro-competitive. And there's a lot of work on that we don't have time for here on that. The claim is, to me, the relevant defense is, for a variety of marketplace reasons, and I don't know what they are, if you enjoin this merger, it's going to fall apart and there will not be any skinny bundling that's offered until somebody else figures out an innovative thing in 2 to 3 years. That makes this decidedly pro-competitive. And this is not what the plaintiffs argued and not what the judge found. But just because you have a plausible explanation of how this is pro-competitive does not mean that it would not lessen competition. And this is, in this way, very similar to something that's very common in antitrust. Just because you have a good reason for doing something doesn't mean you can go farther than you need to go to achieve your legitimate objectives. I could probably be easily persuaded by Jodi and Bobby as the experts that this injunction will make consumers worse, in which case I completely agree with Jodi. But that's the next step.
So we have this, the injunction's been issued. Look into your crystal ball that we all get after law school. Where do we go from here? What's the next step? What happens? Do you think, really what's going to happen? Are the joint ventures going to go like, we're out of here? Or is Warner Brothers Discovery going like, we're going to have less skin in the game, we don't really care? ESPN has a product it's launching, I just talked about. Fox has no direct-to-consumer model yet. What does the court do? Where do you think this ends up?
Well, right now there's a trial date set for March 2024. That's an incredibly ambitious pre-trial discovery and motion schedule, and undoubtedly it will be pushed back. And meanwhile, there may be an interlocutory appeal to challenge the injunction. So I don't think we're going to find our answer in the courts anytime soon. I agree with you, Bobby. I think we'll see technological solutions and work workarounds by these parties and others to give consumers what they want before anything gets resolved in this litigation.
You're nodding in agreement, Steve, huh?
Yeah, I think that's right. I also think there's a good possibility that they redo the venture in some way and to try to void the injunction and then start all over again with something else and see if they can make that work. Because as Jodi points out, I'm not sure that this venture is in the interests of all three parties at this point anyway.
Yeah, look, I think and I've talked about it on this program and with you all before, but you have a change in the world. We live in a universe now of, the majority of the population having now grown up in a native digital environment, and they want to consume content how they want to consume content, which is direct to them. That's why you have all these growing cord nevers. Forget the cord cutters, but younger people who have always just obtained their content through their ISP. And now we have a situation where there's a solution being offered and the court is saying, not good, you can't do it. I think, the consumers will have to speak, and also the people that have paid for these rights. If you are like a couple of the rights holders here are paying $2 billion a year for one sport, you need a lot of income streams. And to keep these people from developing those income streams will hurt both the league in the future to getting those rights and the people that want to broadcast it who are trying to make their money back. But I guess we'll see down the road.
So
one thing that we may also see down the road is, so an interesting aspect of the court's decision was its ruling on the requirement that Fubo demonstrate it will be irreparably harmed and thereby entitled to an injunction as opposed to waiting out the litigation and receiving monetary damages at the end. Right. And this was based on a very speculative prediction that Fubo would finally return to profitability. It has been in operation now for 10 years. It's still running in the red. And the court found that Venu would be sort of the last straw that would force Fubo into bankruptcy, and that amounted to irreparable harm. But the fact is that we still may see Fubo being driven into bankruptcy. They still have no real prospect of profitability in the near term. This litigation is not, this court's ruling is not necessarily Fubo's savior here. So that is another reason why the litigation might go away.
So feel free to edit this out because in order to make it work. But if you feel like including it, Bobby, to me, you have the most expertise here to really comment on this, what to me is the critical question, which is, especially now that Warner Brothers has lost its major content, why does Fox need Disney? And why does Disney need Fox? Cord cut, the transaction costs of subscribing to two bundles aren't that great. So if they were planning on doing this at $42, then why doesn't Disney just do the same model for all its products for $21 and Fox does its product direct to consumer for $21? Or is there some business reason why they really need to, for economies of scale or other strategic reasons, need to do this together, in which case this injunction really has much more potentially anti-competitive effects than it would otherwise have?
Well, I think that the joint venture was put together. When it was first announced, I questioned, how they're getting away with it based upon historic precedent and what rights were available to these the rights holders, because it was, you could distribute, but only your entire package. You can't carve out sports. Assuming that they can do it now, these companies, as the rights fees go up and up and up and up and up, how are you going to get it back? Income, your commercial advertising fees goes up. Fox is charging $7 million for a 30-second commercial in the Super Bowl this coming February. That's a limited amount. Then you were relying for years on cable penetration and your subscriber fees, but those have drawn back dramatically in the last 10 years, from 100 million to maybe 70 million homes that buy the big bundle. And so you've got to find other ways, other returns on that investment. And I think in this case, as I noted earlier, Fox is one of the three that really doesn't have a digital strategy. They've never launched anything like what ESPN is about to launch with their new product in 2025, or that Warner Brothers Discovery has had from the jump. So I think it's an economy of scale for streaming that brought Fox in. And now we have a situation where these people are saying, okay, we're trying to make money. We're drawing an audience in because this audience lets us promote other things we have. But in order to draw this audience, we still got to make some money on this. And thank you, leagues, for giving us other means by which we can make more income to support paying you, the NFL, $10 billion a year. And the court is now saying no and claiming it's anti-competitive when it's really, to my mind's eye, the decision is anti-consumer. That's my
What
opinion.
you just said is there's a standard joint venture law promotes the idea of two parties that have complementary skills getting together to offer a product that neither could offer by themselves. One of the problems with litigation is businesses don't necessarily want to say so. So a narrative that says we formed this venture in part because Fox has acquired all this highly desirable product, largely the NFL, but many, the game of the week on MLB, all these great broadcasters. It may be arguably the premier sports channel, but we suck at digital. And this may be because of some bad business decisions. Maybe we didn't listen to Bobby Hacker 10 years ago, but for whatever reason, we do not have this capability. Disney has already got Hulu. They've got streaming. They know how to do this. We need to join with them to quickly get this innovative product to market because we suck at it and they're better at it. And that did not appear, and maybe I missed it. I did not, in reading the defense pleadings, I did not see that idea that this is a pro-consumer venture to cover up Fox's weakness in one area and Disney's shortcomings. And Disney does not have the quality of product that Fox has. And you don't see that either. So one way to just draw out Jodi's narrative is that this is an incredibly pro-competitive joint venture, principally between two flawed programming companies, but neither of them want to admit their flaws. And it reminds me of the old adage about, married couples where they fight because both of them are high maintenance, but both of them insist it's the other party that's the high maintenance party.
I want to return to something that Bobby just said about how, it's understandable that these programmers who have paid enormous rights fees to the leagues need to find new avenues to distribute and generate more new revenue streams. But I think there's a counterpoint to that, which is that what's going on here in this injunction is you have blocked a bunch of traditional cable TV powers who are trying to blow up the old cable bundle, give consumers what they want at a cheaper price than Fubo does, right? The Disney, Fox, Warner package is using these sports rights that they paid billions for and which glue together the traditional fat cable bundle to unwind that fat bundle by offering customers this cheaper sports-focused skinny bundle that customers have long said that they want. And so to Bobby's point, I'm not sure this is necessarily a new revenue stream because it is going to cannibalize their existing revenue streams. In fact, one commentator in talking about the judge's decision here, the injunction decision here, called what Disney, Fox, and Warner are trying to do an act of thoughtful self-cannibalization, that they recognize there has to be an intermediate step between how consumers currently receive sports content and other content and some future world in which everything, the dust is settled and there are multiple ways to get it, including lots of skinny packages. Right? So I'm not sure that Venu generates new income for Disney, Fox, Warner because it may incentivize many people to not just drop FUBO, which was a court's concern, right? The court was enormously concerned with the fact that the skinny bundle would lead to lots of customers ditching FUBO. But they're also going to ditch cable and other means of receiving this content. So the idea that they're trying to do this to generate a new revenue stream, I think is counterfactual.
We could. I was just going to say we should consider a separate program on antitrust advocacy. My biggest takeaway from this whole thing is that the biggest mistake the defendants made was not hiring Jodi Balsam to shape the narrative of their defense instead of using the arguments that were actually pled in the United States District Court.
Thank you.
Well, look, I think this was.
By the way, just full disclosure, I have no connection, financial or otherwise, to any of the law firms that are representing the three defendants in the FUBO case.
Thank you for that disclaimer. Appreciate it. Anyway, we've gone a little long, but this was really fascinating and really enjoyable for me. Thank you both so much for taking the time to talk about this. I think it's a really interesting case. It's fascinating, not only because it sort of breaks down some antitrust things, but it also takes a look at the sports media business and its change and how it will survive and where it's going. So there's a lot more to this, and I'm sure we'll reconvene at some point to see where we've ended up. Thank you both very much. Really appreciate it. And for those of you turning in, my commercial announcement, sportslaw.org. If you're not already a member, become a member of the Sports Lawyers Association. Thank you all. Thank you, two of you. Fabulous program. Really appreciate it. And we'll talk soon.